Welcome to the HoCo Cyber Collective Podcast, where community, technology, and stories converge.
All right. Thanks, everyone, again for joining us in the HoCo Cyber Collective podcast. Today, I have the privilege of speaking with Peter Davies. He is my lawyer. Helped me from the beginning, making sure that my intellectual property, the Secure Sentinel network, and the idea in general was properly protected. I took one look at the U.S. patent website and said, nope. And I was introduced to Peter through my business incubator. And Peter, would you like to introduce yourself?
Hi, everybody. My name is Peter Davis. I'm a partner with Whitford, Taylor, and Preston. My practice is intellectual property primarily, and that involves patents, trademarks, copyrights, trade secrets, confidential information, proprietary information, all kinds of types of protection for various ideas and concepts and information. And I also basically do whatever kind of agreements and transactions that relate to intellectual property. So if it involves an idea or a concept, then I get involved if somebody needs some help or advice.
Okay. And so if I recall back when we first met 3.5 years ago, you had a very distinctive process for getting the patent put together. Could you share with what is your approach to getting an intellectual property IT patent?
Right. So from my perspective, a patent, a U.S. patent is a hybrid document. It's part legal, part technical. But to the extent that the part which is technical is really fully within the ability, if you will, of the inventor to write and describe, where a lot of patent attorneys will take a half an hour or an hour long meeting and maybe take a couple pages of a disclosure, and then they'll spend the next week or 2 weeks or month bent over their desk billing hours, and with the result of a $15,000, $20,000 or $50,000 patent application. My thought is this is at least part of it, or half of it, maybe 90% of it is a technical document. So I give to the inventors some templates, some examples, and I say, describe your invention as you would to your colleagues, using your words, not trying to put any legal language or anything like that. Just use your words to describe your invention to your colleagues. And here's kind of what the end result will look like. So to the extent that you want to format it in this way or not, I give you a template document examples, and you can try and imitate that. But again, focusing mostly on using your words to describe your invention. And then, and that really is the lion's share of the work. The legal part is making sure that it has all the necessary elements and features, describing it, so that someone could make and use the invention. And then I help the inventor write what are called claims, which are appear at the end of a patent document, which describe the boundaries of what you're seeking protection for. So you might invent something. I use like the car example all the time. You might invent, let's just say, for example, intermittent windshield wipers or a fuel injection system. You'll describe the whole car kind of in relatively general terms. And then you'll also describe that very specific part of your invention. That's all something you can do on your own. And you can call me up and ask questions, and that's a 10 or 15-minute call. Again, I'm not billing you 40 or 80 or 120 hours. I'm billing you half an hour for a phone call. Then you just kind of write a paragraph or two that describes this part or that part. Anyway, I get the document, I review it, I say, add a paragraph here, take this out. That's another half an hour, hour or two at the most. And I'll help you write the claim. Now, sometimes, depending on how complex the invention is, I might take that on myself. Again, that's really only a handful of hours. Or if the inventor has some experience and exposure to patents, they already have a good idea what a claim looks like, and they can really write rough drafts themselves. So using the inventor as the scribe instead of the lawyer as the scribe for the lion's part of the patent document, which gets submitted to the patent office, you get the patent costs, from easily $20,000 down to $5,000, and sometimes even less. Again, I've filed patent applications that have been granted for as little as $3,000 or $4,000. And again, that's because I'm letting the inventor describe his or her invention. and I'm just kind of guiding them, giving them hints and not hints, but advice and so forth on how to write and what to write, but using their words. I find that when folks are trying to imitate someone else's style, it just certainly turns into a disaster, and they're using legalese that they don't understand or is hard to frame. It's not. The goal of a patent application is to inform the relevant public, which is people in your field, your invention. Therefore use your words. And there's things you should and shouldn't say, and I'll tell you what those things are, right? But I'm not going to. I don't want to. There's more efficient ways for me to spend my time than to spend 40 or 80 hours bent over my desk typing something that I may not be intimately familiar with, but you are. That's your baby. It's your invention. So that's how we get it done efficiently, effectively, and using the correct division of labor between the technical description on the one hand and the legal features on the other. So sorry for talking so long. I'm a lawyer.
No, that's exactly what I was looking for. So I'll tell you that I'll speak my half of the experience of that Peter, I happen to have. And so just so people, I'm going to share my screen real quick. Most people don't know what a patent application actually looks like. The way I do describe it is if one remembers what it was like to write a term paper in high school, it's that, except that it is in a language that is not one that normal human beings speak. However, as I said, Peter provided enough examples that I am very good at imitating the style or picking up the syntax. So this is I think it would be fantastic content for us to just sit here and read the 23 pages of, I'm going to scroll through, but, I had drawings. This is a list of all of that. So I used Microsoft Visio. I think I had a total of 11, 12 figures. And Peter, just remind me, so the thing that is important about whether something is patentable or not is that it has to do something. It has to take an action of some sort, or it has to make a change in the real world. Is that
So that's not there's that's one of the elements. There has to be utility. So there's got to be some function. It just can't be
the switch that turns itself off is not patentable, probably.
What's that?
Like a joke machine that turns itself off is not probably patentable.
Well, look, it might be. So the standards for patentability are it's got to be new, right? It's got to be something that nobody's done before, exactly. But it also can't be obvious over something that's been done before,
right? As defined by the patent reviewer.
Pardon me?
As defined by the patent review.
By the patent examiners, that's right. So the examiners will search all the patents and all the technical literature to see if what you're claiming has been done before or whether it's obvious over what's been done before. The invention has to have utility, which means it's just got to have some use. I think what Colin was referring to in terms of there's got to be some transformation in the world. There is a requirement that it be a machine or an article of manufacture or a chemical. There's certain categories of invention. What you cannot patent, though, is an abstract idea, law of nature, those kinds of things. And in the last 10 or 15 years, there's been some decisions from the Supreme Court that have kind of put in heightened scrutiny on whether someone is claiming simply a mental process, a mental operation. So that was related chiefly to certain diagnostic methods and some biotech methods, but also to what we call business method patents. Financial analyses, for example, that were done entirely on computer and that were simply just doing statistical analysis. You can't really patent that alone because it's not producing anything. So there are some rules concerning if you've got what we call a business method patent. There's ways for us now to develop the claims so that it actually does describe patentable subject matter and not merely some mental process. So I'm not sure, Colin, if that's what you were referring to, but we do have to make sure that it covers something.
So at the beginning, and I will say, just for other people that are thinking of getting a patent, this was a very real question, and I appreciate that Peter asked me some questions to make sure that I was able to articulate my idea in such a way that it wasn't going, because it's a lot of work to then be denied, and I knew that that was a very real non-zero possibility. But Peter, in your experience, what's the total amount of time from start to finish that it will take to get a patent? Mine, I believe mine was 3.5 years, correct?
I don't have that number right off the tip of my head, but it really depends from technology area to technology area. I think the patent office likes to say that the average pendency for a patent application is 18 months. I don't, that wasn't your experience, obviously. And so some patents can
Well,
get granted in as early as, a year to 18 months. I think it's unusual for most of them to get done in 18 months. So, the average, and I will say that's my recollection from some time back. So that may be a little bit out of date. I think
sure.
3 years is probably an average time. I've had some that have taken substantially longer. The patent office assigns patent applications to technology areas. And if there's a whole ton of new patent applications being filed in a particular technical area, for example, like the apps that go on your phone, which everybody's filing applications, your patent application might sit for a long time in the queue. But if you're filing an application for a fishing lure, not a whole ton of applications being filed these days on fishing lures, you might get that patent application looked at in the space of 3 or 6 months and have your patent in a year if the examiner finds that it's patentable. So really depends on the technology. For those technologies where the waiting period is long because there's a lot of new filings, there is an option for getting what's called expedited review, and there's an extra fee for that. And the patent office says that they'll get you the whole process in 12 months if you pay that expedited fee.
And I will say again, just as another, just a shout out to this approach, as a small business owner, expenditures on legal fees were necessary. I will say that for those of you that are thinking of potentially going for a patent and want to try to do it yourself, don't just don't. This is one of those things that if you're serious about wanting to protect your intellectual property. Now, I guess here's a more general question that I remember what you told me was that if you get the patent, what does having a patent actually get you? I have a patent. What does that actually mean in the real
So
world?
a patent is a government grant of exclusivity for the technology that's covered by the claim. So you think of the claim as a boundary, almost like the lot lines in a piece of property, a lot,
Right.
in a housing development or a farm or something like that. That's what the claims are. So a patent gives you the right to exclude other people, to make, sell, or use, or offer for sale that subject matter that falls within the scope of those boundaries. Now, what it means to exclude is if you want to exclude someone, you may have to take them to court and file what's called a patent infringement lawsuit. But you can start by saying, sending them a letter and saying, hey, I've got a patent. Here's a copy of my patent. Please stop. Or you can send them a letter that says, would you like to take a license? You just have to keep in mind that if they refuse to stop, and if it's important enough to you, you may well have to take them to court, and that's going to cost some money. But it's not a right to practice. One thing you have to keep in mind is that you may get a patent that doesn't give you the right necessarily to practice that invention, because someone else may have a patent that covers a broader scope. So, for example, someone gets a patent on a car or an airplane, and you invent fuel injection system or intermittent wipers or something like that. Well, you can install your intermittent wipers on a car, but you can't build a car and sell it with those intermittent wipers or that fuel injection system if there's a patent on, an internal combustion, device with a steering wheel and four wheels.
With
You
a
have to wait till
window
that patent
cleaning device of
pardon me?
unspecified nature. With a window cleaning device of
Well, no,
unspecified
so that earlier patent might not make any mention of,
Exactly.
windshield wipers or, fuel inducement systems, fuel injection system. Might say carburetor, or might not even say that. It simply say a way of getting the fuel and the air to mix and then combust. So, and then you come up with some improvement But if the patent on the car, the whole car, is already still out there and not yet expired, you have to make, you can't sell cars without taking a license or infringing that patent. So again, it's important to remember that it gives you the right to stop other people from using your invention or selling it, but you have to make sure before you start going out and selling your invention that there's not some other patent that came before yours,
Right.
On a broader subject matter.
Exactly. And so, and just one other thing, what happens if you don't go after the person that is infringing on your patent? If you choose not to pursue, like, what is the implication of that?
Well, if you let enough time go by and you know that someone's practicing your invention, those infringers eventually have a defense of latches. What's called latches, technical legal term, but it simply means that you sat on your rights and long enough to basically let the world think that you weren't going to come after them. So that is a real defense that's available to infringers who have been infringing for a long time with the what they would argue is kind of the implicit agreement on the part of the patent owner.
Rights for intellectual property, basically. That, hey,
I haven't heard that phrase used, but that's probably one way of doing it. I think squatters' rights probably apply a lot more earlier and quickly. So latches really aren't going to apply for quite a while. I don't know off the top of my head how long it needs to be, and it's probably different depending on the set of facts and when the patentee, owner of the patent, learned about the infringement, whether there are any communications between the two of them. But yeah, I mean, if you don't, and by the way, when you sue for infringement, if and when you sue for infringement, you can only get damages going back 6 years. So if you wait 10 years and you don't, and the defendant, let's say, doesn't raise the latches defense, well, they can say, well, you can only go back 6 years. So you can't get, even though they've been infringing 10 years, you can only get 6 years worth of damages.
And then on the other side of it, what happens if your product, you got your patent, you've managed to now make a product that uses the patent, and one of the, we'll call them big cyberco, notices your product that you've started to sell, and they build an imitation of it and start selling it. And you have a patent, so what do you, and this is a much larger entity, what do you do in that instance?
Well, that's a tough call, right? Because you can reach out to them and say, hey, listen, I've got a patent that might be related to your technology. Is there something you'd be interested in talking about? And that way you invite a friendly conversation. You're letting them know about the existence of your patent and inviting a friendly conversation. You can tell them, so that's option one, which is probably, recommendation number one.
Yeah.
You can send them a cease and desist and say, here's my patent, you're infringing it, you better stop now. The downside to doing that is that if you aren't ready to sue them, they could sue you for a declaratory judgment, for a statement by the court that they don't infringe or that your patent's invalid. So if you threaten them, if you will, or create in their mind a certain expectation or anxiety that you might sue them, but they don't want to be hanging on. I think like say you're sending their customers infringement letters and things like that. They have the right under the law to get a declaration from the court that they don't infringe or that your patent's invalid. The problem and that maybe that's okay, maybe that's not. The problem is that if you're in Maryland and they're in California, they're going to file that declaratory judgment action in California. So now you have to go to California to defend a case that maybe you weren't ready to litigate yet.
And these companies have on staff legal help.
Oh, they're far, whether they do or not, and many of them do. But they're likely, if you're just a sole inventor or a small company, they've got the wherewithal to do it.
Right.
So I say that most of the cases I discourage folks from sending a strong cease and desist letter unless they are ready to sue. Your third option is simply file a lawsuit, and you file it in Maryland if that's where you are, in New York if that's where you are, but you file it in a jurisdiction that you think is favorable to you, whether for location or the disposition of the judges and so forth. All the courts in the U.S. have different views on patents and patent defendants and patent plaintiffs and all that kind of stuff. So now you we haven't gotten into that, but but you can't file everywhere. You can only file where the defendant has, is located or has substantial business, or where they're infringing. So you have to be able to
was
get
filed in
jurisdiction.
Maryland, I think. So
Pardon me?
mine was filed in Maryland, if I recall. But yeah, it's
Your what was filed in
my,
Maryland?
my patent was filed.
Well, your patent was filed in the patent office, right? So we're talking about, if someone's infringing, where do you file a lawsuit? Right.
So, in your best estimation, just order of magnitude, if someone still wants to go ahead, what is the amount of time and money to be appropriately legally staffed for this effort? What should a business owner expect?
We're talking about for filing a patent application, or for litigating
we just described, where big cyber company is infringing, and then the little guy actually wants to go through with it. What's the just order of magnitude? Again, we're not going to hold you to these numbers, but just tens of thousands.
Right. So a patent litigation, start to finish. This is old data, but I want to say data that's probably 10 years old. But I haven't heard any significant updates. But let's just say 10 years ago, they would say for a value for a matter that was worth, I think it was, let's say, under 10 million, you should expect $2 million in legal fees, start to finish. Now, that sounds awfully low to me, but that's been 10 years. And for a matter that was worth over 10 million, then I think you're looking at $5 million in legal fees. So again, if you kind of advance those numbers by 10 years with all the inflation and so forth that we've had, I think you're probably looking at, reasonably, $5 to $10 million. Now again, that's start to finish.
Thousands, we're talking millions of dollars.
Right. Now that's start to finish. That's assuming you go all the way to trial, which might be anywhere from 18 months to 5 years, depending on the court you file in. And these are all federal district courts. They're all federal courts, but there's anywhere from 2 or 3 to 15 federal courts in the various states. So there are some states that are very fast. Virginia is Northern District of Virginia. It's very fast. There are districts in Texas that are very fast. There are other districts, wherever you file, because that's where the defendant is, or that's where you are, where they take a long time. But the longer it is, the numbers go up, just because,
right.
That's the way of the world. But
But
I will say that most patent cases by far, and I think it's probably something like 90-95%, something like that, settle long before trial. So there's only about
doubt. Like, how actually talk about that a little bit. Like, how much of it? This is like these theoreticals that I feel like don't actually come to pass. What do you ever see that these small companies that hold intellectual properties use the threat of litigation as a tactic for getting purchased by the larger entity? Does that make sense?
So the threat of litigation is less relevant than the value of the technology to the large company. If the patent is strong and the technology is important, then you may never even get to the threat, right? Because they just look, this is a great patent, this technology, dynamite. Let's just take it, then fight. Because during the course of the lawsuit, the owner of the patent could license it to some other competitor of the big player.
Right.
So these cases that go on a really long time typically are between really big parties who have the ability to fight, Goliath against Goliath, right? And they both have the wherewithal to fight, and the legal issues or the factual issues are not so cut and dry. So they just battle it out, until the court makes a decision. But when you're talking about a small company versus a large company, if the technology is important and the patent is strong, covers it, is got a long term, then more likely than not that the big company might purchase it or license it. Right? It makes sense, because then they can lock out their competitors.
Exactly.
Right?
And then they're the ones that are now fighting.
Right. But if they find a way to design around the patent, or they don't think it's worth what the inventor thinks it is, and there's a lot of things there, then they're going to say, look, it's costing us less to litigate than the inventor wants us to pay for the license. Right?
It's a math
So
problem.
it's always a cost benefit analysis on both the patent owner's part. It's a small company with a new patent, and the big, the big giant company who's copied it, who likes the technology. So when
So
you're writing a patent, you have to ask yourself, if I were a competitor, how would I avoid infringing this patent? So and then when you write the patent, you try and cover all the potential design arounds, all the potential optional ways to do steps A, B, or C, or to accomplish, certain
right,
tasks, functions, so that, you make it more difficult for someone to find an easy way to avoid infringement. And if you can do that, then it makes it more difficult for competitors and potential infringers to find what we call an easy design around, an easy way to avoid infringement. If you sue someone and they're like, good, if we make this small change to our product, we won't infringe, the case may or may
do
not be
that.
over, but your chances of winning suddenly, took a nosedive.
Right. I remember, and I'm thinking back to when I was writing this, that you advised me that you wanted to write broad enough that you cover your idea to, just as you said, to prevent workarounds, but not so broad that it's too big, too obvious, or more likely there is a previous patent, prior art, I think is the
Well, right. You can't get a patent for something that's already out there, right?
yeah.
And examiners sometimes will stretch the prior art, right? And you want to get a patent, so you have to write claims that avoid that don't cover something that's already out there or something that's obvious already out there. But you do want to make sure that you cover your patent broad enough to cover anybody who's going to try and copy or imitate your invention, or for that matter, someone that comes up with it independently, but after you.
Right.
So yeah, it's a balance between uh, getting the claims as broad as possible to give you the broadest amount of protection, but also, try and not cover the prior art, or trying to avoid or be able to give yourself the ability to overcome rejections from the patent office that say you're claiming too much, which is very
right.
common. Now, if they do that, you can amend your claims, which is common, very, very common. So you got to give yourself some backup positions as well. So make sure you have as much detail in your description of your invention in the patent application, so that if you get a rejection from the patent office, you can add more detail into the claims so that you can avoid the prior art,
Right.
avoid the rejection, overcome the rejection.
If I remember correct, so I've pulled back up my patent, and this is, I will say, the claims part was the hardest part of the whole thing, because this was the most regimented. You are describing every single step, and if I remember correctly, we got a partial, not rejection initially, but it was in your mind, and we succeeded. We got the patent approved. Peter had found a way to, with a relatively uh, small change, you were able to address that completely. And then, actually, if I remember correctly, we then got the patent approved shortly thereafter. If that's
Yeah, my recollection was that there was some rejections, initially from what we call an office action. The examiner issued some rejections that were fairly easy to overcome. I'm guessing from what you're saying, Colin, we amended the claims in some way to clarify the language a little bit, or
Yep.
to add a little bit more detail, to add another step that the prior
literally
art.
less than a paragraph. It was like a little blurb that you added,
Right,
and that was
right.
it. Which was
So
a huge
we
relief to me. You were
yeah.
excited, and I'm like, oh, okay. Because you get these, again, speaking as the person waiting for there's a lot of waiting in the patenting, for a whole lot of nothing happens. And then all of a sudden, Whitford Taylor Preston sends me a whole bunch of things all at once, and I'm like, what's this? Then I think when I got it approved, um, we were FaceTiming with my wife, and I were FaceTiming with my mother-in-law, and I look at my phone, and I'm like, I think my patent just got approved. It was just like, but hold on, I have to make a call, and I called you up and went, Peter, what am I looking at?
Yeah, so it can be overwhelming when a first rejection from the patent office comes in to an inventor, a patent applicant who is unfamiliar with the process. It can be daunting, but the examiners, look, they're just doing their job, and some of them are more experienced, some of them are less experienced. I find that experienced examiners who've been doing their job for 5, 10, 15 years give 2, 3, 4, 5 page rejections, which are easy to process. They kind of get in, get out. Meanwhile, new examiners who are being trained and they've got to cross every T and dot every I. I mean, you get 30-page office actions, which are just kind of mostly just, you didn't put a period at the end of the sentence, or, you used an and instead of an or, there's a lot of that. And then there's a lot of kind of over interpretation, if you will, of older patents, what we call prior art. But the package you get when we send you this office action is a copy of the 5 to 30-page office action, which and then we give you copies of all the prior patents that the examiner relied upon. So it's a lot, like I said, it's daunting, but I will say that typically, and I was an examiner, so I know how they think. Before I became a lawyer, I was a patent examiner. If my advice to the applicants is, there's usually just one or two issues that are stuck in the craw, if you will, or that form the major basis of the examiner's rejection. And that's usually, you can find it, and on experience, you know where it is. You can find it quickly. You say, look, I know that if we address this one or two issues by the examiner, all the other ones are going to be easy to resolve. So I would say, when you get, no matter who your patent lawyer is, if you get a rejection, don't panic. Just say, all right, all right, what do I need to do? Because I don't want you to read a 40-page office action, give yourself heartburn, read, dozens or hundreds of scores of pages of old patents, when there's only 2 pages of the office action I need you to read and 1 early patent, and say, look, tell me why your invention is different from this patent.
Right.
And we'll make sure that difference is reflected in the claims. And, more often than not, the rest of the issues are very easy to resolve. But it's very easy to panic when you get that first office action.
The word reject has a very understood meaning to me, where I'm like, oh dear. But no, that's, again, I will reiterate, if you are seeking to go down the path of getting a patent, get a lawyer. It's the best money you will spend. I guess, taking a step back, so we've been talking about patents, and a lot of people, I think patent when they think intellectual property. Could you talk about the difference between intellectual property and, say, trade secrets or trademarks, all the different?
So that's a good question. So that's all intellectual property. An important distinction to keep in mind is the difference between a trade secret and a patent. A patent, to get a patent, the trade-off is you get this exclusivity for a period of time in exchange for disclosing to the public your invention. So it's really, in the purpose of the patent system is to encourage innovation by sharing information. So to encourage you to share the information, the government gives you this exclusivity, limited exclusivity for a period of time. Trade secrets, on the other hand, is something by definition you keep secret, right? You never disclose it. And so in order for something to qualify for a trade secret, and you have to keep it secret. That is to say, you don't tell all your investors what your secret sauce is. You don't let all your employees know. There's only 2 or 3 employees who know what the secret is. If there's an investor who says, look, I want to drop a bunch of money on you, you got to really weigh it, because the more people you tell what the secret is, the less it becomes a secret. And if some former employee leaves the company and uses your trade secret, and then you sue them for trade secret infringement, they're going to say it wasn't a secret. He told everybody about what it was and how it worked. And everybody who thought about dropping $10 as an investment, he said, oh, here's the secret, here's the secret sauce. When you hear about the kind of the traditional trade secrets like Coca-Cola or Kentucky Fried Chicken's, secret recipe, those things were under lock and key. There was only a very few number of people who knew what it was. And those standards have kind of been codified in the Uniform Trade Secret Act, which most states have enacted. So there's fairly high standards for demonstrating what the trade secret is and that you in fact kept it secret. But I will say that there is value to that, because there are some inventions, some concept. Well, let me say, some things that aren't eligible. For example, a customer list isn't patentable, but it could very well be a trade secret. If you spent 5 or 10 or 20 years building a customer list, and your customer, let's say your customers aren't everybody in the world, because everybody has an iPhone, everybody
Right.
buys toilet paper or paper towels or whatever, but you've got some product which has a very specific market, and you spent a long time trying to figure out who those customers are. That customer list is trade secret. Now, you can't patent it, but you should definitely keep it secret, and you should make sure that all your employees know that it is your company trade secret. It's highly confidential. You make sure that you don't distribute it more widely than is
Right.
necessary. So that, and again, recipes nowadays with the chemical technology, the equipment that is available to laboratories and scientists and so forth, engineers, they can pretty much figure out the chemical composition of anything.
Right.
So if you come up with a new nutraceutical, a new pill, a new drink, or new medicine,
Right.
and it's just a combination, let's say, of existing products. Well, let's see. So that's patentable subject matter. You have to ask yourself now: is it new, or is it old, or is the examiner going to think it's obvious? If you think it's not obvious and not new, then file a patent application. But if you think that it's going to get rejected at the patent office, the problem is that your application gets published. So the world's going to see it, and then it's rejected. So now public sees it, and you don't have a patent.
Right.
So you have to make a decision. You can try and keep it trade secret. Of course, the downside is, like I said, using this modern technology, it won't be long before somebody does an analysis of it and figures out what's in it.
Right.
So again, the question is, I think for trade secret is if you have a secret which isn't reverse engineerable, if you put it out in the public and people can't figure out how it's made or what it is or what makes it up, then it's eligible for trade secret protection. You just need to make sure that you treat it like a secret within your company and with potential investors.
Right.
But if it's something that as soon as you start selling it or using it, the public is going to be able to figure out what it is,
Right.
then hopefully if it's eligible for patent, meaning it's not just a customer list, it's not just a mental process,
Right.
then you should talk to a lawyer about trying to get patent protection for it.
That's yeah.
So that's trade secret and patents. You talked about trademark. Trademark is a method of protecting your brand. All right. So you come up with a name for your product. You think it's a cool name. You want to make sure other people don't start. Let's say that you start building a market and excitement over your product, and somebody else says, "Wow, that I'm going to sell the same thing and use the same name." That would be trademark infringement. So as soon as you start using a name or a phrase or a word in commerce to market or sell a product or a service, you can start to accrue trademark rights, assuming that it's got to be, it can't be generic. Like if you're Joe and you sell apples, you can't trademark Joe's apples. It's just descriptive, right?
Right.
But if you sell computers and you call it Apple Computers, then yeah, you can trademark that, right? So there's some requirements for trademark protection, but if you've got a cool name and you've got a product or a service and you want to sell it, it's a good idea to talk to a lawyer about using it in a way that will begin to develop the trademark rights. You can register a trademark with the U.S. Patent and Trademark Office. That gives you some additional rights, different from patents, though. Where a patent, you need to get the patent grant in order to have the rights. Trademark, as soon as you start using it, you start to accrue rights. Registering that trademark with the Patent and Trademark Office gives you a leg up with respect to a handful of those rights. You have what they call prima facie evidence. Just means you don't have the burden of proof in a trademark action that you were the first to use it or that the mark is distinctive. If you don't have a trademark registration, then you have to prove in a trademark litigation that you were the first to use it and that the mark is distinctive. So there is a benefit to getting a trademark registration, but you do begin to acquire those rights as soon as you use it, even if you don't get a registration.
Gotcha. Yeah, I remember. So what I did specifically for my business was, it was the name Sentinel Forge Technologies. And then we trademarked the hammer. We called it the Cyber Hammer. That you had this really great advice of, if you use your marks. Like McDonald's, I think the example you gave was McDonald's using their M in their, like, they put the M on their fry container. That is an extension of their brand, and therefore the way that the McDonald's fry container looks also becomes covered by that trademark sort of thing. Where if I'm a French fry, if I'm a competing hamburger shop and I have, a fry container that has an M on it, and McDonald's considers me a competitor, they have the ability to do trademark infringement because I put an M, even though I'm the McDaniels Corporation. Too bad McDonald's did it first, and therefore they can do it.
Yeah, a trademark is a designation of origin, right? It lets the public know who is the origin of the product or services. So once you get a trademark, like it's an M, right?
Right.
Somebody and you have it for, whatever, fast food or whatever. Somebody else can't use a big yellow M
Right.
to sell their fries, because then that's a false designation of origin, because that M is associated with McDonald's. I
I'm a
told
McDaniel.
Colin's got this really cool looking hammer logo. I said, look, that's a very cool, a very distinctive looking logo to, and I said, somebody could easily like that and then start using it. I said, get a trademark on that, get a registration for it. Because, again, I thought that it was very distinctive. We
Yep.
didn't have any evidence that anybody else had been using it before. So getting the trademark was fairly easy.
Yep.
Very inexpensive to get a trademark relative to patents. I mean, start to finish under $3,000.
Yeah.
And
The
sometimes
trademarks actually faked us out a few times that we got the approval for that. I'm like, yeah, we got it. Oh, okay. It's the I trademarked my name.
So you thought the trademark approval was the patent approval?
Whatever
Yeah.
I mean, there was basically three things basically that you guys assisted me with. It was the trademark of the hammer image, the trademark of the words Sentinel Forge Technologies, which was something so you couldn't use that in a logo and pretend to be me. That gave me broad protection that I could use against infringement. And the hammer was something that I deliberately include in most of the artwork that I am creating, so that I'm extending, as you can see, even on the logo that I made for our little podcast thing, it has the little cyber thing. It's almost in a way, it's the look and feel of that logo. So once you have it, you can use it as part of it. I'm not claiming that that's mine, but it's a very distinctive, easily, used. That, like you said, it looked kind of cool. So,
Well, wait. So when you said you're not claiming it as yours, I mean that is yours. The hammer. What are you talking about?
no, the hammer's the thing. Maybe you can't see my mouse. Actually, you probably can't. So the this thingy right here.
Okay.
That's in the style of the hammer, but it is not the hammer itself. If I put the hammer there, that would be an extension of it. But no, I totally have the hammer. But yeah, you can't see my mouse moving over on my screen.
Yeah, no, the nice thing about your hammer mark is that, you if you use it on all your products and all your promotional materials, it becomes immediately associated with you and with your product. So anytime anybody sees the hammer logo, they know that it's a Sentinel Forge product.
Right.
And because not everything is going to accommodate Sentinel Forge technologies, put that hammer everywhere, whether it's a product or something like that. And again, people immediately associate that whatever that hammer is on, and they know that it's your product or your service.
Right.
So again, it's great to have a logo, a little image, something very distinctive, very cool, in addition to the name of your product. The name of your company, it can be trademarked as long as you're using the company name to market your products or your services.
Right. Yep. Yeah. It was a good mix of things on that. And again, it was fun to do. So, the one-stop shop at Whitford Taylor Preston. And again, it's a good thing to have a lawyer like Peter, who I appreciated that you also get advice on what it wouldn't have necessarily occurred to me to trademark certain aspects of it. I genuinely don't necessarily plan on, hardcore selling these products, but I guess, especially if you're a new startup business and you're thinking about getting investors, the way that I thought about it was if you had a patent, you can say patent pending. That was my prime concern is you can legally and ethically say this product is patent pending, knowing full well that it's going to be in that status for, in my case, multiple years. When you're talking to investors, having a patent makes your idea more of a tangible thing. Um, the one thing I'll say, and maybe you can speak to this, we say these are my patents. Technically, in reality, these are I have assigned my patent to my company. Again, I am a LLC, single member LLC registered in Maryland. I am a corporate. This is a corporation that is technically an immortal entity. People can come and go from it's not me personally who's owning it, it's the business. Same with the trademarks and everything else. So if and when you do a business acquisition or something, those are the assets. You're would you agree you're making your business more appealing for an investor or someone to buy? Because there's
Well, I mean, an investor is going to be a little bit reluctant to invest in a company if the purported assets of the company are held by an individual,
right.
right? So I think that when we talked earlier, I said, look, there's benefits, there's pros and cons to you keeping the patent in your own name, and there's pros and cons to putting the patent in the company name. And the pros are keeping it in your own name is that if you lose control of the company, you still have control of the patent, right? And I've seen that happen where somebody, on both sides, where somebody lost control of the company, they were lucky enough that they still had some leverage because they owned the patent. I've also seen it where they lost control of the company because of, power plays or investment came in, took a majority share, whatever, and the inventor was forced out and the patent was already in the company's name. So I said, you kind of have to weigh it, but to keep in mind that if you ask an investor to put in 10,000, 50,000, 100,000, $1 million into the company on the force of this technology, smart investor is going to say, well, what's to stop somebody from copying the technology and my investment's gone. You can say, well, I've got a patent. Well, he says, well, who owns the patent? Right. And if the patent's not in the company's name, he says, well, then why should I invest in the company if the company doesn't own the patent? Right. So
Gary in accounting holds it. We hope he never leaves because then we'll be doomed. That sort of thing is what you're talking about. It's risk.
Well, no. I mean, an investor, I think, is going to. If I were advising the investor, I'd say don't invest in that company until the inventor. If the technology is patented, and you think that, and it's important to you the patent, because a lot of times they say, look, let's just say there's no patent. They might not invest because they're going to look. I'm going to spend $1 million, but then somebody else is going to simply read your patent, copy it, and compete with you,
right,
for free. Right. So they want to see a patent. That's why it's important to at least say patent pending, to file a patent. Right. A lot of times they don't.
That brings up a very important point that I want to point out, that when we talk about patents, this is all everything I've shown on my screen. This is all public. You can search for my patent, search for my name in the U.S. patent, and it is public knowledge. That's what's special about a patent. And I think, Peter, you told me that whenever a patent, and I've actually experienced this because now I started to get junk mail. Like there's like an ecosystem out there for people who have just gotten their patents approved. And my buddy John, who again is probably listening to this podcast, got really excited because he said, "Colin, there's something from the patent office on your front porch." And I'm like, "Oh boy!" And I got there, and it looked really official. But then you read in small print, "Not affiliated with the U.S. Patent Office," and it was. I had the opportunity to purchase a lot of very beautiful mounting options for my new patent. Like, no, you don't get like the framed thing from the government. You have to do that yourself. But they knew, like, I think you said that they looked at two things: how worthwhile the idea was and how big the entity was that held it. So there was the concern about if it's just an individual inventor versus a university, that is holding it. Can you speak to that?
Yeah, I don't know. I'm not sure what you're referring to. I mean, when you're talking about investors and what they're looking at, I mean, obviously
No,
what
no,
they
no.
care
I'm talking
about
about
is,
potential infringers. There are potential patent infringers that look for new patents that are being published to decide, hey, that's a really good idea. Let's try to infringe. And then you told me that the what they
oh, yeah, no,
who
I
holds
think you're
it.
probably, yeah,
Yeah.
let's try to infringe. You might be thinking of a different conversation or a conversation with
Gotcha.
someone
Yeah,
else. I mean, there are companies that acquire patents for the purposes of leveraging them, to sell packages of patents or to sue infringers, right?
is that what a
So,
patent troll is? I think I've heard of that.
well, there's yeah, that term's kind of fallen out of favor, but there are companies out there that acquire patents for the purposes of asserting them. Um, and those were of old called patent trolls. Now they're typically more referred to as non-practicing entities, right?
Okay.
Meaning they're holding companies and they're litigation companies, right? Or
They
they'll call
exist to
themselves all
sue.
kinds of things to
Yeah.
avoid the stigma.
Right.
I don't have any experience with companies that search the new patents and decide, oh, here's a new cool technology.
Right.
Let's buy the patent or let's acquire to get a license because we think it's new. I mean, more likely what happens is, big companies have their patent departments or their product development departments, and they're keeping an eye on competitive, technologies that are getting patents for a couple reasons. Number one, there's good stuff coming out, and they want to make sure they stay on top of the industry. Number two, they want to make sure that they're not infringing their competitors' patents. And get back to the first point again, like I said, the purpose of the patent system is to encourage innovation. So if someone's out there watching patents getting issued in their industry, oh wow, that's a cool idea. Really cool, but we know of a better way to do that, right? And so that's the whole idea, is that the patents build on each other. So I don't think that there's anybody out there saying, "Oh, here's a patent, let's infringe it." But here's a patent, that's a really cool idea. We think we can do it one better and get our own patent. You know.
So here's a question, just thinking about the rise of AI tools like ChatGPT. You've probably heard about there were some lawyers that got themselves in very, very, very big trouble with a judge because they cited cases that did not exist.
Yeah,
Um,
we've all heard those stories.
how do you see, or have you seen, the rise of these AI tools, specifically maybe around writing of patents or the whole patent industry? Because ChatGPT is something that, in theory, can ingest patent data and then write it out. Have you encountered anything like that?
We have seen that. We are getting pitches from companies that have what they call patent searching software, patent indexing software, patent all kinds of, searching and analysis tools. They've been around for many, many, many years, and now they're all enhancing their product offering with AI, right? Now those tools typically have not included patent writing services, but now that AI's come online, some of them are starting to offer patent patent writing. I don't know. We don't use any of those yet. I don't know that we will. But look, it's come so far in just a very short amount of time.
Right.
It's very possible that we'll see patent writing get a big boost from AI. It's so powerful already, and it just needs to be trained on the right type of documents for it to be able to do a good job, I think.
Right.
That being the case, I think that unless you're somebody who's got a lot of experience with patents, whether you're a patent lawyer, patent agent, or just somebody who's done a ton of patent work, and there's a lot of folks out there that just know a lot about patents because they've read a lot, written a lot, whatever. But in the absence of a lot of experience with it, I would be very reluctant to advise someone, oh yeah, go ahead and have AI do it, because there's a lot packed into a patent application. A lot of things that should be in there, a lot of things that shouldn't be in there. And it's going to be a long time before I'd be confident letting AI write an application without significant amount of supervision.
I agree.
But
Think about
it's
this.
coming. What's
who,
that?
Who is in control of that AI? Like, I know there was a new, I think DeepSeek is a Chinese LLM competitor. if you take your patent and your diagrams of your intellectual property and you upload it to that server, who now owns that data? Could you even patent it anymore? If you have placed a copy of your idea.
Yeah, no, look, I think that, look, I mean, you got to be careful. A lot of people, you got to be careful about, for that matter, just type in, if you've got a new invention and you want to see if anybody's done it before, you type it into Google, right? Well, I mean, you haven't given your invention to Google, right?
Right.
But you've given the folks in the back office at Google insight into your invention. Now, I don't know to what extent Google or any other search engines are harvesting searches for the purpose of finding inventions.
Would we know?
Well, no, not unless somebody sues Google, and but who knows? I mean, the fact is, there's all these companies now that are suing the AI companies for copyright infringement, because they used their works to train, the language models.
Right.
And some of those are getting hammered pretty good. So, I don't know. Who knows if Google or any of these other search engines get sued for, intellectual property misappropriation or something like that. But absent that kind of situation, we're not going to find out about it.
So how many? Actually, I'm interested because I've been following along this AI stuff so I'm an individual user of these, but a lot of these companies, I believe, are pivoting to the business applications. How many people are pitching you something as a new way that is now AI enabled or something like that, would you say?
We are getting a lot of clients are coming to us with patent applications or what we call invention disclosures that for which AI is a feature or an element. The just saying doing ABC with AI, you're not going to get a patent on it, right? It's too conceptual.
How do you write AI? Like, what is AI in the world of the patent?
Well, AI is using trained neural networks, right, to do analyses and things like that, right? So, to produce, information or documents or language and things like that. So AI is just sophisticated, trained software. I mean, it's not magic, right?
No,
it's
software that's telling it. So I would even argue that, if you remember the early days of video games, and a computer program where if the light is green, the door opens, if the light is red, it closes. That is a decision tree that is artificial. That is technically, to a very primitive extent, AI. This is just way more advanced than what it's doing, but it's still, at the end of the day,
it's following a set of instructions.
Yeah.
So like I said, we're getting a lot of applications where people say, now, like if the invention is already patentable, then adding AI, describing it in some way or another, improving its functionality by using AI, then sure, adding AI is gonna help it. But if you got a quizzical look on your face, what's the question?
I'm thinking about it. Just thinking about it. So the people that you have come to you with AI, where is the AI actually running? Is it running locally at the place where the service is being done, or does it include some kind of cloud?
Yeah, none of the disclosures that I get that relate to AI are focused on where anything is happening. It's all just kind of generally saying, look, here's a new functionality. It's either, usually it's software. So here's some functionality. We've developed an app for doing this or for doing that. And as part of the processing of the data that's received or input or something like that, they use AI to process the data. And the AI is trained on that type of data to improve the decision making that's going on in whatever this new invention is. So that's really what, all the applications that I've seen that are kind of, if you will, tossing in AI, it's really improving decision-making processes.
Okay.
In terms of speed and in terms of accuracy. That's what I've seen is they're increasing it, 1,000-fold, sometimes even more, by using trained neural networks to make these decisions.
Gotcha. So the reason I ask and the reason why it's important is that it's this again, my background, we talked about this way back, is on the hardware level, where you're talking about software, which I would assert software doesn't work without hardware, which means that that software must run on something. And typically, what is being done is that they're going to the cloud, which is great. It's a fantastic platform. It allows you almost limitless amounts of resources if that's what you want. The problem, and this is me putting on my solution designer hat, is that they don't account for the cost of those resources, because when you're in the cloud, you're effectively renting. You're not buying. Um, run Running these AI things consumes immense amounts of resources. One of actually the things that sort of come up is that it's not actually that great for the environment, just because of the sheer amount of compute resources that are being consumed. Um, and speaking from my own experiences, I use a lot of these tools. I've actually asked ChatGPT, hey, how much did this chat, based on your knowledge of your own operation, cost? And it's like, well, based on my estimates of current prices, $50 to $70 for the one conversation. I pay $20 a month for ChatGPT. Who's paying for the resources? There's venture capitalists that are funding this right now, because if you were to run this locally on a computer that's next to you, it'd be horrible. It wouldn't even run. There's just not enough, like the amount of resources, like we don't as individual users really comprehend how much fancy computing stuff is happening in the background here. The reason I bring this up is a lot of these software products, they tend to get in this, they get trapped in the cloud, where there's, again, these are agreements where, have you seen where there's a cost for like leaving the cloud? So once you're in, if you decide, oh, it's costing too much,
Oh, yeah, yeah, yeah.
now
Yeah, no, I
they're
haven't seen them, but I certainly, exit contracts and exit
exactly.
features and so forth. Penalties are common. They're trying to keep you in there, right?
Hotel California is what we called it. That, and worse, I don't want you to, if I am with cloud provider A, I don't want my customers to go to cloud provider B. I have absolutely no incentive to make it easy for someone to switch, and frankly, quite the opposite. And everybody's doing that. And so what's actually happened is that people think of the cloud and they literally think of it, again, this is something that to me the cloud has been a marketing term that has been a bit of a thorn in my side for about 15 years now, where we got very hand wavy about how things worked, where it's like, oh, it's in the cloud, it's in little particles that are in the flight fluffy, like, no, it's in a data center somewhere else, owned by someone else, and you rent it. That's what the cloud is. And Microsoft makes, all these big guys, they have remarkably robust data centers. But at the end of the day, you're a client. You're basically renting an apartment in a really, really, really big apartment building, as opposed to owning the home where you can now make decisions. And this is fine unless hypothetically Microsoft takes down their entire network accidentally by that, and everybody's email goes down, and you can't just call the IT guy and yell at him to make it go back faster. You can call an 800 number and you will get in line, because none of their individual tenants are anywhere near as large as Microsoft. So it's just, there's a trade-off. Again, I speak as a user of Microsoft and they make great products, but at the end of the day, they're not my tech guy. They're just part of my infrastructure. They provide me Teams meetings, things like that. So I guess, speaking a little bit more, just my realm of things, what's, to the extent that you can tell, how much work does your firm do relating to cybersecurity, or that sort of
We do a lot. We cover every aspect and feature of cybersecurity. We obviously do IP relating to cybersecurity. We have a team of folks that address breaches. We have a team of folks that do privacy, terms and agreements and all that kind of stuff, and cyber deals and all that kind of stuff. We have a folk that does, we have groups that do both sides of, front and back of cyber response. And advising them how to prevent them from happening, or how to protect yourself when it does happen, and how to, and there's all kinds of reporting requirements when there's been a
Oh, yeah.
breach. We take care of all. So there's a gigantic legal morass, when there's been a breach, so we counsel folks on how to avoid breaches and what protections to take, what insurances to get when it's available, how to respond, and we take care of the response, and we coordinate the forensic investigation into, what happened and how did it happen, that kind of stuff. And of course, and of course, naturally the legal response, which is required by the federal and state laws and regulations relating to cyber. So
Right.
We've got a fairly deep and experienced bench on everything related to cyber.
That's fantastic. I guess first question I would have is, all those services that you provide, are they typically being paid for by the end client themselves, or is there usually some kind of insurance, like a security insurance vehicle that is paying?
Yeah, just like IP insurance. I mean, it's out there. It's a product that has been pitched from time to time. I don't know how expensive it is. I know that most folks that try to get patent infringement decide that it's not worth it just because it's too expensive, and then and trying to make a claim and all that kind of stuff. I suspect that while it's trying to evolve, the realm of cyber insurance is probably even more uncertain.
Well, yeah, because here's the challenge, that when it started to be offered, these are insurance providers are big on risk mitigations. They have their actuarials, which are trying to figure out what's the likelihood of a breach. So they suddenly were faced with all of their people who were buying business insurance, specifically asking for this thing called cybersecurity insurance that not even the insurance providers had heard of. But their customers were asking for it, so they said, well, okay, here you go. Here's a premium, and here's the coverage, with no data about the actual amount of cyber attacks that were happening. Very quickly, it became apparent that their initial actuarial assumptions about likelihood of payout was grossly not covered by the premiums they were charging. So a lot of my clients during this period were getting 300% increases in their premiums year over year. The other challenge was, just like you listed all of these services you provide with regards to, what you do in event of a cyber attack, so too did these insurance products. They would handle the notification, they would pay for the notification, they would pay for the remediation work, they would have relationships with, preferred IT providers. This is like an HMO, except that there's no law against doing this with computers. So you can totally just funnel business to your preferred provider, not the client's preferred provider. And the last one they always would tuck in there is they would help with paying of the ransom. So what happened was that the hackers quickly realized that, hey, if somebody has $5 million in insurance, that means they can afford a $5 million ransom. And so what they would do is and I asked the insurance providers, hey, what happens if the hackers demand the full balance of the coverage? And they were sort of quiet, as if no one had ever really asked that before. And they're like, well, paying the ransom is only a small part of what this is supposed to cover. There's all these other things. And I'm like, I don't think the hacker's really going to care. That sounds more like your problem, not theirs.
Right.
So what do you do if the hacker says, I know you have coverage. I have a digital backup copy of your policy, and I'll delete everything in 24 hours unless you pay me the full $5 million. Now, what are you going to do?
So let me preface by saying we're now a couple of steps at least outside of my, what I would call my sweet spot.
Totally.
But to answer your earlier question, we get paid by the client. The client's got insurance, or the client doesn't got insurance. That's really not our issue. Now, if we need to negotiate with insurance company, then we'll do that. But we expect payment from our clients. We'll help them negotiate if they have insurance with their insurance company. But to answer your question, look, that's a risk balancing. I mean, the fact is, if your data is locked up, what do you do? You know what I mean? I think, I mean, I don't know. I don't know the answer to that question. I think everybody's answer is going to be different, and it really depends on what data is locked up. And when you talk about a ransom, you're really talking about somebody whose data has been encrypted, right?
This
And it
Baltimore
doesn't, and
City.
I don't know to what extent. Maybe the business model for these guys is, well, we'll always de-encrypt it when we get paid, because otherwise our business model falls apart, right?
Yeah.
Well, I mean, you can't carry on your business if all your data is encrypted. So, I mean, if it were me, and this is not a legal answer, it's not even an
Right.
experienced cyber AI, whatever you want to call it, but if all my data is encrypted and I got to choose whether to pay Peter or Paul or Mary or Simon, and Simon's the one who's got my data locked up, I'm going to pay Simon, and I'm going to worry about how to pay everybody else.
Right.
Now again, but that also depends on what kind of contracts and agreements I have with my lawyers and my insurance company and everybody else. So I don't look, that's a mess. I don't even know. I don't know the answer to that question.
It's a nightmare. There are no good answers. Which again, that going back to our early conversations 3.5 years ago, it's terrible. The only solution is you can't let it get to the point where the ransom is in your hands, because at that point we're cashing in the life insurance, basically. A lot of too many companies, I don't know the exact numbers, but a lot of companies, they just close the business. Like, well, we're done. That's just we have too much of a reputation hit. If you could just share, like, what is actually when does a client have to report upon a breach, like a successful breach?
Yeah, I know there are thresholds. I don't know the answer to that question. I'm not on the cyber team, but I could
But
get
basically,
somebody like that.
when stuff actually is proven to have gotten out to the dark web, usually around health information, financial.
Well, I mean, look, there's categories of information that are considered, protectable. It doesn't have to make its way to the dark web, I don't think. I think as long as there's been a breach and there's been an export of data, if there's any part of the collective of the what's the word I'm looking for, of what's considered protectable information, then you have to report it. I think the threshold's fairly low in terms of type. I don't know if there's a threshold with respect to whether it's 10 users information or 1,000 or 1,000,000, or whether it's 2. I don't know. I don't know the answer to those questions. I know there are thresholds for all of those things and reporting requirements. And the crazy thing is, it's different in every 50, there's 50 different states and federal. And then the fact is, if you've got overseas operations, they're different in Europe and everywhere else. So,
oh yeah,
if you found a breach, you better call a lawyer fast.
Yeah, that is sound advice.
Because you're liable not just to the hackers and to your customers, but you're liable to the government.
Right. So I'm glad you brought this up, because this is something I wanted to share, because this relates again to my product. Again, it's called Guard Tower. The whole idea is that you have to detect these before they happen. And I'll ask you, I think you probably know, but just how long does a cyber attack take to fully execute?
I have no idea, man. Don't
So
you?
how long do you think? Just pick.
So what's your question again? How long do I think for what?
How long? So say the Baltimore City ransomware attack, so basically bad guy gets into the environment you're in the news, everything is encrypted, Baltimore Sun's on the other line asking for a comment. How long do you think that process takes to execute?
I don't know, 24, 48 hours?
24, 48 hours. So I'll give you credit. You are closer than most. It's a little bit higher. It's on average 4 to 6 months to fully execute. And most people, I've actually gotten answers as low as 5 nanoseconds, I want to say.
It's a lot. It's hard for 5 nanoseconds for it to get in the Baltimore Sun.
I have my black hoodie around here I could dress up at as it, but they think that a hacker is a dude that looks like me in a black hoodie, banging on a keyboard in the dark in his, mom's basement, and it's way more boring. But what I showed you, can you see my screen, Peter?
Yep.
So the kind cybersecurity professionals at MITRE have put together what they call the MITRE attack framework. And what this is documentation of literally every single adversarial technique that we have ever encountered in the wild ever. And if it looks complicated, it's because it is really complicated. Cyber attacks are hard. The reason it takes 4 to 6 months, like forgetting what this is, put simply, this is a roadmap for how you and I could break into an attack. You start at the left, the goal, you start at reconnaissance, and then you're moving to the right, at which you're steadily, because usually these attacks happen with a pesky human. There's one person who clicked on a link, someone who went to a website, someone did something that we all know we're not supposed to do. Now the bad guy is on one device, one user account. Thinking you're from how many users and devices are there, in the whole environment? I'm asking for Whiteford Taylor, like how many
What's your question?
how many computers and users are in your organization? Roughly.
Hundreds.
Dozens, hundreds?
Hundreds.
Okay. So one computer is not a lot. That's not going to do a whole lot, but the hackers know that. So they start at reconnaissance once they're in. What's on the network? Where can I spread to? How can I elevate my privileges? How can I compromise all the defenses that the law firm has in place? How can I disable all the notifications, give myself super user access? How can I research ways to cause as much damage as possible? Do they have access to intellectual property as part of ongoing litigation? Are they working with like a larger organization? One time, my aunt's law firm was working with 3 others for a large university for a discrimination case, and as a result, these 4 law firms each had in their possession a large amount of the university in question's intellectual, data. That was what they were after. 3 out of the 4 law firms got breached and the data was stolen. The only one that did not was my aunt's. So that's really the problem. But that happens over here at the right. That's what we call exfiltration and impact. And the notification requirements is what we tell is it happens here. When we know it's happened, they've progressed through the whole thing. They actually got 8 terabytes of data. They got 20,000 records, and then they got that out. That's when usually you have to now notify. Does that jive with what you've seen?
I can't even answer that question. A lot going on here, and
That's a great
I
answer.
cannot.
I love talking to a lawyer. You guys live less.
I cannot refute anything that you've said so far. I got loads of questions, but that's for another day.
Sure. Anyway, the whole point here is that it takes a long time and it's really hard. That's what you should take away from here. But that's where you stop them. That was the whole point of my invention, was because it takes so long. If we deliberately lay traps for these people, I can show a demo of the guard tower environment right now. If you actually, have you ever seen it?
I don't. Well, I'm not sure I know what you mean by a demonstration. I certainly haven't seen a live demonstration. I think I've seen you do simulations, and I certainly imagined loads of them as we were working on your application.
Well, this will be fun then. Hold on, if you'll humor me on here. I will share my screen here. Not that. All right, can you see my screen?
I can now, yeah.
All right, so Peter, you and I are cyber criminals. We're playing the role in this little story. We have broken into a brand new victim. It is a local service provider called the Cybersecurity team. We purchased their chief security officer's login from the dark web. You can see here is totally real username and password. And even better, we have access to his laptop at their primary data center in downtown Baltimore. It's a machine running Windows 10. And here's the address of the computer on the network. And the first thing we are going to do, now that we are in here, is we are going to scan the network and see what other devices are on this network. And before I can even finish explaining to you what happens, you'll see on this console up here, fortunately for the cybersecurity team, they use Guard Tower. So as soon as we began doing our scan, the cybersecurity team's incident response team is receiving a horde of notifications that, dear guard tower user, an investigation worthy event has been identified on the network. Here is the address of the computer that is responsible for that disturbance. I will point out that is us. We have been caught. I wasn't timing it, but remember, this takes 4 to 6 months for us to successfully get in. We just gave it away in the first minute.
Well, hold on a second. I got a question for you.
Sure.
This IP address that you uploaded, you told me that was Jay Blake's laptop, yes?
Yes. So this is received by the security team, and to your point, they know that, oh no, this is the CISO's laptop. We know exactly the computer that is responsible for that.
Well,
And
they received the attack, right? I got you.
exactly.
Okay, so we don't know where it's coming from yet, but we know who got it.
Well, we know what computer
We
it's
know how it came in. Yeah, we know what door it came in. Okay.
Well, and here, let's do one more. So let me put this over here. So I just, on the hacker side, I found like, hey, one of these devices seems to be interactable. So you know what? Let's use this login and see what this guy had access to. Let's put in his super secret password, and we're gonna sign right in. And well, that's weird. Nothing seems to have happened. But if we go back over to the alerts, we'll see that another alert has come in that tells us that, hey, just so you know, someone with this very specific username and very specific password just tried to log into one of our deployed AI decoys. If that is Jason Blake's real username and password, which again, the defender knows, they now know one of two things. Either one, that username and password has been compromised, or two, the individual associated with that username and password has been compromised, because we're also insider threats are the big. What if this guy's being blackmailed? What if he knows he's being let go? What if he's just made a poor life decision? There's any number of reasons why the guy who signed off on the defenses might go bad.
So, but if he's the CSO, the CTO, or whatever his title is, then why would he be addressing network resources, which he should know are
That's a
decoys?
really great question. And what can we infer by that? It must be someone who doesn't know better and tried to, again, we're
All
tricking.
right, I got you.
Well,
but here's from my perspective, what I found interesting about your invention was, I mean, look, this data, maybe it's available in other systems, maybe it's not, but what I found, and what I'm sure the patent office found, is that where your invention was different from everywhere else is, as soon as there is a detected unauthorized access, the system multiplies the number of decoys.
Yep.
And gives the cyber attacker all these
shadow networks and stuff like
shadow targets,
yeah.
Right? And so it depletes.
I don't want to give too much away, but that's future updates are going to do more of these.
Oh, I guess I don't remember. I know it was all in the patent application, so it's public, right? Because it's in your patent application. That's what you got a patent on.
Well, and that's the thing. You can see, and this is the interesting part, I would say, most interesting part for me is going between this is a patent. And here's the one thing that I'll say. When I wrote that patent, I did not have a implementation of it in person, because I was, and I think I told you this, again, you're talking to a solid C undergraduate for comp sci. I'm not good at programming, and so I could describe this product, but I couldn't build it. So
you haven't built it, and that's very common in the patent situation. You don't need to have built it in order to get a patent. You just need to be able to describe it, so someone in that field can build and use it, right? Yeah. So that's when I think about your invention. Look, the detection and the response, that's all old hat from my perspective. Again, and I'm minimizing the importance of those things significantly. But what I thought was really the big deal was the immediate and gigantic generation of all these decoys. So you diffuse the power of the attack, diffuse and confuse. I don't know if you've used that before. I just made that up, but that's what you're doing.
But yeah, it's
so that, you know, they've got so many more resources to try and investigate, to take away the resources of the attacker, and at the same time giving your detection team the time to investigate, because all these resources are getting expelled on vacant, empty shadow decoys. I think it's a dynamite solution.
It is, and so I want to tell you a funny story about when we were putting it together, when I was testing it, and basically the reason why I am no longer allowed to test on our home network. So one of the consequences. So again, we can discuss about, you know, spinning up and creating new warrior sentinels was the term for them. But on the practical side of it, and this is getting a little into the weeds, but just so you know, the IP address scheme, that's the numbering system, how like addresses on a house in a neighborhood where you can know who's what and where. There is a finite number of those addresses that are available on most home networks, and this is very important for our story here. I use Google Wi-Fi. Google gives you, just with its normal default configuration, about 200 individual addresses to attach things: TVs, computers, phones. Now, you'd agree that in most cases, 200 is plenty of addresses. But if hypothetically you had a device that was capable of spinning up large numbers of new things very quickly, there might be some uh, consequences that you hadn't considered. So I was doing a testing, and I just never really thought about, like, I was doing stress testing to see, you know, we tested on the hardware how many of these things can be spun up, because this was important to the warrior thing. To answer your question, we found that it was possible to go from having 20 deployed to 2,000 of these things deployed, and we were not maxing out the hardware that we were testing on, which was really exciting. I mean, you now have, again, thousands of things that are protecting you. I tried to spin up 300 of these warrior sentinels on my home network, which only had IP space for 200. And my wife, who works from home, came into my lab and said, "Honey, I just got kicked off my computer. I can't work anymore." And I said, "Uh-oh, that's probably me. Here, let me get on my laptop so I can fix this." Huh, my laptop isn't connecting to the network. And it's like, oh no, I have so thoroughly filled up the IP space, and the thing is now hanging because it's only been able to spin up 160 of these things so far. And the second that a new IP address became available, it would immediately snatch it. And even if I took everything off of the network, it would still not finish because I had completely saturated my own. I had effectively did a cyber attack on my own network using my cybersecurity product. So I'm no longer allowed to do that sort of testing. I have a completely isolated network where we're sitting in the virtual podcasting studio. But that was what somewhat tempered, I guess, a little bit of the warrior sentinels, because here was the cool thing that we found with our testing, Peter, was that if you had 10 of these AI decoys or 1,000 of them deployed on the same network, the rate at which they would send alerts actually didn't improve. It was just as good with 10 as it was with 1,000. So while there are benefits to giving more targets, and that is definitely something we're going to develop, we realized that if we were too enthusiastic about spinning up these things, we could, because there are actually some networks that.
No, yeah, you can crash the system. I'm just curious though as to why or how the reporting rate is the same. Because look, let's say that you've got a network of, and I don't know how many available, it's a big company. So let's see if you got 10,000.
Yeah, you can get it up there, 10,000.
Right. Let's say 10,000 units on the, you know, on the network. And and let's say that the space is available for 1 million, or let's say 100,000. So it's 10 times as large as the current use, right? So 10 decoys in a population of 10,000 is a fairly modest proportion, right?
It is.
So
Yes.
so wait, let me finish. So I'm curious, is the answer still the same, that the reporting rate at 10 among those 10,000 is the same as 1,000 in those 10,000? Because now you're up to 10%. How can the reporting rate be the same between 10 on that 10,000 and 100 on 1,000?
So that's a fantastic question, and I'm going to try to, before I answer this, how familiar are you with computer networking and how these things actually work in the back end?
Modestly.
And again, I can answer this question in any number of ways. I just want to understand the language level you would prefer for me to explain.
All right, you explain it in your language, and if I have a question, I'll ask it. How about that? That's how I usually roll.
Okay. So, are there networks that support 1,000, 10,000, potentially hundreds of thousands of things in the same network? Yes, I would imagine. I mean, what is Azure or Google?
All right, so hold on. Let's back up for a second, because I think you're trying to change the question, which is okay, but I want to make sure. Like, is the rate? So my question is this: is the rate of reporting? Let's say you got 10,000 used addresses with an availability of 100,000. So it's only using 10% of the available addresses.
Right. So what I'm trying to say is that if the network is actually big enough that it needs to have that many addresses, and there are places that do.
Yeah.
You are never, ever, ever in the real world going to encounter what's called a flat network, where everyone can talk to everyone else. That 100,000 users is going to be chopped up into, if you think about how many physical locations there are.
Yeah.
You know, it can get extremely down to where at the end of the day, your computer plugs into a switch, or you're connecting wirelessly to a wireless access point, which plugs into a switch at some point. And so in the real world, you could, yes, hypothetically, could a flat network exist? It makes my head hurt, and one of the reasons why I was a C undergraduate was.
So let's hold on. I don't want to make your head hurt. Let's do this. Let's take it down. Let's just take it down to 1,000. Let's say you got 1,000 addresses.
Gotcha. What?
And there are 5,000 available addresses, but only 1,000 are being used. Okay. Now hold on one second. Let me finish. I don't know if it's flat or not. You can break me up again. But
10 versus
what
1,000.
I'm trying to understand is why 10 sentinels, the reporting rate for 10 sentinels would be the same as 1,000. Well, not 1,000. Well, yeah, let's say 1,000, because you got availability of 5,000. So now you've doubled the number of sites from 1,000 to 2,000 and a 5,000 availability. How isn't that reporting rate going to be substantially greater than the 10 on that network?
It is. To answer your question, how is it the report's volume look when you increase it? Oh, it goes up dramatically.
All right. So now back to the question from a practical standpoint, the reporting rate, whatever that practical environment is, the reporting rate of 100 is not substantially greater than 10 because of practical considerations, the way the networks are configured.
The speed of the alert is the same. The amount of alerts is much higher, but that presents its own problems, because now you're potentially sending hundreds of alerts, and one of the big things that defenders really are struggling with is noise. They have so many tools these days that are all sending alerts. And so what we were really envisioning was a tool that remained utterly silent, except when you needed it to be making an alert. And that, because of the thing I talked about before, that there are going to be some environments where because again, think about how home networks are now conceivably part of the enterprise. We have work from home people. They might not have a huge IP space available, and you would break. The worst thing that I always thought that I could do, and one of my core philosophies with this was, this shall do no harm. The worst thing that a cybersecurity product could do is initiate a cyber attack by its very operation. So we tweaked it. Again, the idea is still there. There's still validity in the idea of swelling up while you're under an attack. It's just it has to be a lot more controlled, very much within the claims that we still have, that you helped me write. But this is where we get into when you and I first started talking about this. I used to say that nothing should touch these things. Zero, and when I said nothing, I meant zero. Then you get into the practical reality of when a this is we're dealing with things like computers work the way that they work. As you said, I always have to remind people these are not magic. These are things that we had in the 60s and 70s and 80s, and electronic messages or emails are not new. They are very well understood. So, and which is why we can spin so much of these structures up. It's because they were designed in a time when computers were much, 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 much less powerful and capable. And now you can buy for $100 on Amazon a computer that probably had more power in it than what put us on the moon. And they're considered disposable. That's what we're taking advantage of, is this compute is just lying around.
Right. So it sounds to me like what you're doing is you're having, now that you're doing practical implementations of the invention, you're encountering situations or circumstances that may or may not have been anticipated, but you're finding solutions to those. So to bring this back to IP, I would say, look, as you're finding those solutions to problems
Right.
that are encountered when you implement an idea or a concept, or even something that's already patented,
Right.
those new solutions are themselves patentable. So I'm talking to you, Colin, now instead of your audience. If you've, to the extent to which you've had to make changes.
Yeah,
and
just so you're worried about
adaptations.
TradeWinds is handling all the intellectual property stuff on the development work that we've done since this went from being a cool idea in a lab to a for real product that you can actually buy. And to finish up the thing that I went into, that practical thing, think of this as like a cyber landmine that if you trigger it with too much force, and it doesn't take a lot, it'll explode. Well, imagine if you had a landmine that if you tried to bury it, the weight of the dirt set it off. That wouldn't be super useful. That's what we actually found when we hooked it up to a network. Every so often, whatever network device or that you're connecting to is basically talking to your computer that you're using and saying, hey, are you still there? Do you still need this address, or have you gone away, and can I take the address back? That is a perfectly natural thing, and it happens in the background, and it's so innate that we don't even think about it. That's just part of the noise that exists.
Yeah.
That was setting off the initial traps, which that was like, well, that's too sensitive. So we basically made sort of a threshold system that, because again, that if we think about this in proportionality personified, like that's like down here as a threshold. Someone doing something like a network scan, like I showed you in my demo, that's off the chart up here. It is so much louder than, this is a whisper versus an air horn. So it just was a matter of just, again, the interesting thing of practical application versus theoretical application. And the fortunate thing was, because of your advice, I had written my patent in such a way that instead of talking about zero, we talked about thresholds that were defined by the defender. And so that little wrinkle that we found in the real world, because I had written my patent correctly, frankly, like you'd advised me to, it wasn't a problem. It was just more of an intellectual curiosity that, oh, this works different than I thought it would. But no, so that I guess thank you for sharing all your insights on everything there. Was there anything else you wanted to talk about, or just I'm really interested, I guess, in the implications for AI in your profession. So I guess you said you had lots of pitches for, these new AI products. If I was some slick cyber tech bro that was selling you on my AI patent attorney, where through the powers of AI and large language models and machine learning and deep learning and cyber magic, I am asserting that an AI can do exactly what you can do, but better. I guess what would be your rebuttal? Like, why do you think that your role is still going to, even in a world with AIs, that there's still value in someone like with you and your experience? I hope that question doesn't throw you off, but
No. I guess. Look, I think if somebody said I'd have to see it. You know what I mean? Show it to me. I mean, you could say anything you want. People do that all the time, and it's getting worse and worse every day, right? So if somebody said, "Look, I've got an AI, that can write a patent application as good as any patent attorney," I'd say, "Well, show it to me."
I
And
got a
if
question. How would you break that AI? Knowing what you know, what situation would you put it in where you feel like it would fail?
I wouldn't try and break it. I would just test it. I would
But I
test it
want
and
you to
test
break
it. And what's that?
That's where the fun happens.
Well, I mean, look, I don't. The problem is if you set out to break it and you can't broke it, then you're broken, right? That's not the way I roll. I mean, I manage my expectations. I mean, look, I'm gonna give it a reasonable go, right? And so if I'll give it an easy test, and if it passes, I'll give it a more challenging task. And if it passes, at some point I'm gonna say, look, it's damn good. Now that's not saying I'm gonna trust it 1,000% of the time, but I would tell my clients, I said, look, how much is that software gonna cost you to buy? I'll bet you it's more expensive than it is to have me write it for you, because I don't charge $20,000, $25,000 a patent application because of the division of labor. I'd say, here's what I'd recommend. You get that software if you want, and then have it write your draft like the way I've always done it, and then send it to me to proof it. Right?
Exactly. So I guess
now the fact is, we'll see. I mean, look, it's a long way away before AI can do everything I do, and that's probably true for most jobs, right? Because even if you can write a patent application, then it's got to get into the human element of responding to office actions. That is a whole, I mean, now there's a human element involved where you got somebody on the one side giving you a rejection. You got to get into their head. Now you're not just responding to, so I say, look, AI is not a long way away from writing patent applications, but it's probably a good, 20 years away from writing, if it ever gets there, on responding to office actions that were written by patent examiners.
Gotcha. Now let's rewind there. So if I was the one selling this, that I had used the strategy of selling effectively I'm not selling to you. I'm selling to your boss or to your boss's boss to say that the reason you want to spend large amounts of money on my AI attorney is because there's some total cost of ownership that by effectively downsizing or right sizing your firm of these pesky partners, you could save money or something. Like that's the value. It's an adversarial thing. What if I came and I was talking to you and said, I have an AI software that doesn't replace you, but it acts as an assistant to you to make, because
we're getting those. Look, I don't know if you asked one or two questions. Everybody that is selling us AI tools are billing them as attorney assistants or whatever to help the attorneys do their job more efficiently, more effectively, or whatever. So
gotcha. We're not at the replacement phase. We're at the enhancement phase.
No, look, law firms aren't built that way. They're institutions that are, I don't know, 800, 1,000 years old, 500 years or whatever. You know what I mean? It's kind of like the merchant guilds in Venice. You know what I mean? They're been around forever, and the structure is kind of very old, and it's very, what's the word I'm looking for?
Deliberative.
It's very traditional, right? So
not prone to flights of fancy.
What's that? No. But what I'm saying is that law firms aren't trying to reduce their numbers; they're trying to increase their numbers because they make money off of billable hours.
That's a true point.
So they have to change their whole billing structure.
100 hours, you can bill 1 hour. Wouldn't that be great? Like,
yeah. And the fact is, look, if lawyers started hiring AI to do the work of lawyers, not just assist, then the problem is, then they've lost their edge in the market, because then why hire a law firm? Just buy the AI lawyer. You know what I'm saying?
And I would say that I think a lot of you're right, it would be highly disruptive. And the problem is, I think with a lot of the Silicon Valley is that they seek to disrupt. They want to get into an environment, shake it up, like shake up the ant farm, like Uber or Lyft or something like that for the tax industry. Through that disruption, they're not really particularly concerned that like long-standing institutions might be shattered into.
I don't care what their motivation is. I'm just telling you that that's what they're up against, right? I'm no Nostradamus, but I'm saying that, look,
better, I guess.
I mean, that, look, there's LegalZoom's been around for a long time now, that kind of stuff, and it does a great job for some things, but it also there's also, flaws in it. I mean, every single set of situations, whether it's technology, whether it's a divorce, whether it's a will or setting up a trust or an estate, has idiosyncrasies that LegalZoom, for example, or even AI isn't going to be ready to handle, right? So if you have the run-of-the-mill will or this or that or whatever the heck it is, yeah, go on the LegalZoom, but you're always taking a risk every time you do that you have one special circumstance that isn't accounted for, and it's all, and it's those one. And again, I'm not trying to pitch lawyers over LegalZoom or not. All I'm saying is that,
No.
I'm a lawyer, and if I pull something off the website to use as a template for something, I go over the fine tooth comb. Well, if you're not a lawyer, if you're not experienced doing that kind of stuff, you don't know what to look for to see whether or not the document you're using addresses all the little aspects that are particular to your situation, right?
Right.
So I think they're fantastic tools for the educated user, or for the user that's willing to educate themselves. It's like that expression, I know enough to be dangerous, right? Well, that's the
Right.
problem with these, and it's going to same thing's going to be true when AI comes on full online for, when it's available to the public to use as your personal
Substitute for
AI
a lawyer.
lawyer, is that, you're never going to know whether it is as trained as the lawyer who's lived and had real conversations with real people in that field, whether it's IP or corporate transactions or wills and estates or whatever the heck it is, real estate. You know what I mean? Real estate, another thing, just so many crazy different things
Right.
that are involved in every transaction. It'll get there someday, but it's a long way off.
Well, yeah, and it's a long way off until it isn't, and it's just the thing with AI is, and this is just more of a general statement, that I agree with you that I think it's going to be a while before they figure this stuff out. Except that I've been surprised before, and working with these AI tools that are now available for $20 a month. It's like I'm living in Star Trek as far as I'm concerned. Like, this is
Oh
incredible.
yeah, I don't disagree with that. Look, I mean, the phones, like you said, that talked about off the shelf, products. You can launch the space shuttle with your cell
Yes,
phone.
right here.
It's
And
crazy.
actually, I imagine that helped with, imagine intellectual property, where you talked about people have like a paper copy of the recipe of Coca-Cola. Well, now you got to worry about that your entire workforce, every single one of them, is carrying around a supercomputer that has a microphone, a camera, a connection to the internet, internal storage. They might be an unwitting accomplice if you get a malware to get into the environment, or you just take a picture of that recipe and you've effectively stolen it, and you just have to get your phone out, which is a little bit easier than getting the actual recipe out. I imagine.
Well, yeah, I mean, that's all of that's true, and I think that, I mean, the good news is the public are more and more educated about, what things to click and what not to click. And when you get an email that looks like it's from your bank, don't open it. Just go to your bank's website, and all that kind of stuff. So, I mean, yeah, I mean, there's there's dangers lurk around every corner, and unfortunately, the bad guys are faster learners and innovators than the white hats. But we just got to be vigilant.
It is. It's sometimes is a little just discouraging, but you're right that that's the problem that I tell people that we think of cyber attacks and hacks and ransomware like a big storm, like it's a hurricane, that it's a thing that we can understand, we can plan for it, we can do things like, I have my primary data center and then I have a secondary data center that's many miles away, and I have a stated failover plan, because we know this storm is coming. But it leaves out the human element. Like, there's malice and human intelligence. Like, these are not naturally occurring things. These are actual physical people that are directing it. And what I say is, it's more like the hurricane that then hits your primary site, then your backup site, and then it backs back and forth over and over until it's flattened both of them. Then it sends you a ransom, because and that's one of the things I worry about is, as Guard Tower makes its way into the market, the bad guys are going to run into it. Well, how are they going to react? And we're hopeful that we've been ahead of that. Um, if I can humor you if you'll humor me real quick, I'm putting together this. You mentioned about people knowing not to click certain things. The one thing that's usually true for people that are sort of our age and younger. But the challenge that I run to is that people that are my parents, my grandparents' age, around there, they did not grow up with computers. And so they are being victimized. And basically, if you and I get an email from someone that claiming to be the Crown Prince of Nigeria, promising us $10 million if we assist, I would agree that you and I would not click that link because we know that's a big load of baloney. Problem is that a non-zero number of people are clicking that link. And so how do we solve that? So to that end, I put together share sound, share. All right, can you see my screen?
I can now, yep.
All right, so let's put this on.
Boss, I'm telling you, there's a new racket hitting the streets. It's called fishing, see?
Fishing? What are we, opening a bait shop now? What's next, worms in the safe, see?
Not that kind of fishing, boss. This is through the electrical letters. You send a note that looks real classy, like it's from the bank. The poor saps hand over their dough faster than a mark at a shell game.
So, let me get this straight. You don't crack a safe, you don't stick up a joint, you just ask them and they cough up the loot?
Exactly, boss. One click and you're swimming in suckers. Yeah, see?
Listen, boys, that ain't a score, that's a scam. Only a mug falls for that kind of grift. And anybody listening out there, don't be a mug. If some so-called banker asks for your password in an electrical letter, you slam the door faster than we scram from a raid, see?
What do you think about that? Did you get the references?
Yeah, of course. Yeah, I mean, it's cool. You
Did
asked
you
me how
watch those
effective I think
movies,
it would
though?
be for educating my mother.
So here's the question I'm asking you. You recognize that motif of the tough guy gangster, right? Where do you know it from? Did you watch those movies?
No.
So here's where I know it from. Bugs Bunny. Because those
Well, I know it from Bugs Bunny, but but the fact is, look, popular culture is infected with, and I don't mean that in a bad way. I mean, those things are pervasive. They're in every, they're in Coca-Cola commercials, beer commercials. They're in other movies referencing old movies. I mean, so it's very familiar motif.
So my thought was to make a series of them that, again, this is specifically targeting, basically baby boomers. Like my mother who watched movies, loved it. I think my mother-in-law and my father-in-law both laughed for 5 minutes straight. My dad thought it was an insult to his generation, but he didn't really he didn't watch movies back when he was young. So I'm like, ooh, well, I wasn't going for insult to the generation, but it was trying to make a pop culture reference to.
Yeah,
I don't know
I
who those
think, look,
people
my
are.
mom's 86. Yeah, 86. And she's very sharp. But I'm afraid that the delivery might distract from the message, right?
Yeah,
And in terms of effectiveness, it's cool. It was neat. I liked the whole thing, but my attention, and I'm at the very end of the baby. I was born in 63, very into the baby boomers, right? So
right.
my attention was drawn to, oh, I recognize that guy and the voice. Is that his voice or is that a made up voice?
No, these are again.
No, I know, but what I'm
100%.
saying is that the delivery, right, which is that cool very thing that you did, is so cool that it's distracting from the message, right? And I know what the message was. So as it was playing, I understood it.
Right.
But if it was telling me something I didn't already know or trying to get me to do it, I'm afraid that it might have just gone. I might have
Right.
had to replay it 4 or 5 times. From my perspective, the most effective way is to say, here's an email that, Mary, Jones got from her bank.
Right.
She clicked on it. Look at it. Yeah, wouldn't you click on that? Sure you would. And she clicked on it, and here's the bad shit that happened to her. She lost
Right.
all her life savings.
Yeah.
Don't do it. You know what I mean? And here's why. What's happening is the bad guys are so sophisticated now So if this happens, don't ever click on an email ever from anybody unless it's, you know what I mean? And if they're asking for money, if they're asking you to put in your any sensitive information, just go directly to the place you know is safe, right? I would say tell the I don't know how scary you want to make it, right?
If they
But
ask
I
for
think
gift
that
cards, say no. That no
what?
one asks for gift cards for official payments is the one like little tip.
Right. I mean, the fact is, look, the IRS is never going to call you. They're never
I
going to
need you
call
to go
you.
to Dick's Sporting Goods and get me 5 $100 gift cards to pay your
Well,
taxes. Like,
right. You know, so I don't know. I
people
mean,
do
it's
that,
very cool.
you know.
And I think that, you know, that stuff, but I think that again, sometimes the cooler it is, like sometimes you see these awesome TV commercials,
Right.
the Super Bowl commercials, and it's over. I'm like, that was the coolest commercial ever. I don't know what they were selling.
Well, exactly.
What
So
good of a
here's the
commercial
thought
is that?
Well, and here's the thought is that again, this podcast, we also have this a YouTube channel. So the thought would be to have movies that I want people to, and as an aside, if you've ever done a YouTube channel, you actually want people to watch the videos multiple times.
Yeah, no, I get that too. Sure.
So the thought would be that this would be a way of providing that education. The thought would be that, like, I guess my question for you is, if you watch movies at all, what's the name of an actor and actress who you immediately think of bad guy? This person plays villainous characters.
Geez, I don't know. I don't know. I mean, you know.
Darth Vader, James Earl Jones, Charles
Well, he
Dance.
doesn't know. If you're talking about a bad character, I can name it, but if you're an actor who always plays a bad guy, you know, I was going to say Jack Palance, but I don't, you know, I didn't watch enough Jack Palance movies, but the recent ones, he was a bad guy. You know what I mean?
Okay.
Long dead now.
Actually, that's a perfect example because I actually don't know who Jack Palance is.
You'd recognize him.
I probably would, but I don't know his name. Just the same way, if you ask me that question, I'm going to say people like Christopher Walken, or it's a generational thing where based on your generation, whoever is the answer for my parents is they gave me a whole bunch of people who played these old gangster characters. Never heard of any of them, but I was able, thanks to the internet, to look them up. And I went into one of my AI tools, which generates voices, and I created 2 AI voices: the boss and the henchman, which I'm planning on reusing. So those were the 2 characters that they're repeatable, and I had ChatGPT generate the script with the instructions of refer to modern things. Like, this is the whole shtick: is that imagine if gangsters from the 1930s tried to comprehend cybercrime through their understanding of technologies. Like, they don't even know what the internet is, and you're saying they're like, so wait, like, they just ask for the money and they give them the money? Like, yeah. Why? Because they got a letter. What kind of letter? An electric letter. What does that even mean? You know, just they're being befuddled. And then having the message of, hey, if you see, and we're going to do one for phishing attack, ransomware attack, identity theft, wire fraud, all these things that, you know, using the language that, again, you and I are not actually the target demographic, frankly, for this. Although we might be the one who forwards it onto the target demographic. You might send this to your mom and say, hey, mom, look at this thing. Like you said, she's sharp. My hope is, and actually I'm really interested genuinely in the feedback, is because I'm not looking to be like patronizing or insulting to previous generations. I'm trying to make a reference that they would get. They're probably not used to doing that much anymore. They're probably,
well, again, you know, look, I don't want to, what's the word, yuck your yum, you know what I mean? But I would say, like, from my mother's perspective, she would better appreciate the more direct approach.
Okay.
But she may be I mean, I think she's unique, right? She's my mom, you know,
Yeah,
she's great.
absolutely.
But I think that from her, just knowing what I know about her, she would more appreciate this is what happened, don't do this, you know what I mean?
Okay.
This, you know.
I'm actually going to take that as feedback because, again, the best part about this, and again, one of the great things about podcasting is that it doesn't have to be one or the other. You can do both, just have different playlists, because you're right, no one is perfect. Every message can be now, but this wasn't really possible before. We can now tailor things to, you have a set of videos for the people who want the direct practical approach, who probably understand technology way better than maybe their peers do, that don't need to have the dumbed down, oh, you're talking to me like I'm an idiot sort of thing that we well-meaning professionals sometimes do by accident. I learned this from working with farmers, that you got to learn how to speak like a normal person, frankly, or they're not going to understand what you're talking about at all. So awesome. Well, Peter, I really appreciate you being so generous with your time. Before
Pleasure.
we sign off, is there any pitch you want to give? So and we'll share all this information. So if you're a young a young adjacent inventor like myself, and you're in need of a lawyer, can you give information how they can reach out to your firm and everything?
Well, you can reach me at pdavis@whitfordlaw.com. That's the best way to reach me. And you look, I'm very, as Colin will tell you, I'm very liberal with my time. I want to help inventors understand the process, understand the costs and the ways to mitigate those costs. All of the time I give, telephone conversations, video, whatever it is all at no charge, unless and until I say, look, now we need to establish the kind of lawyer-client relationship, at which time you can decide to say, yes, I want to continue with you, or I want to hire someone else, or I have all I need, I'm going to go try and do it myself, all of which is fine. I just want to help you kind of understand the landscape in order to help you make the best decision. So again, that's pdavis@whitfordlaw.com. Email me anytime and I'll get back to you quickly. And then if you know Colin, you can reach out to him, and if he supports,
I got his number.
He's got my phone number, so I don't want to put it out there too wide. But it's also, if you look, you can find me on the internet. Yep. Peter Davis at Whitford, Whitford, Taylor, and Preston, and all my contact information there as well. So I really enjoy talking to inventors and new business owners and old business owners and longtime business owners about their IP and anything that impacts IP. I like what I do, and I'm going to keep doing it for a long time.
It shines through. And again, I've always enjoyed our interactions, and I always have to have a little stopwatch because Peter is a very good listener. And as you know, anyone who knows me is that I can run up a real big bill real quick if I'm not careful. So, but he's also good at calling that sort of stuff out. And just to reiterate, if you are looking for ways to keep costs down as a new business owner, which we know that's key. You don't have, especially if you're getting your ducks in a row, you don't want to be taken advantage of. This is real stuff. This is something you should budget for. This is probably the most efficient way. It's hard work. It took me 3 weeks of work to do the patent myself, but I bill at a $0 per hour when I'm writing it. And again, it was just a highly efficient use of this resource that I got access to. And again, Peter, thank you for everything again for getting.
Well, yeah, before I go, I just want to make sure I don't leave out the fact that we're part of a general practice firm. And so we have really kind of every type of law here, and everyone here at the firm has the same kind of approach. So reach out to me no matter what kind of legal issues you have, and I'll make sure I put you in contact with someone who has the same approach that I do, to making sure that you have all the information you need to make the right decision. Do I need a lawyer? Are you the right lawyer for me? What are the options that I have? From big to small, it doesn't make a difference. If you've got a question that's a $100 question, we'll answer it for you, and maybe we'll charge you $100, maybe we won't. And obviously, if you got $1 million question, we'd be happy to handle that one too. So,
yeah. And again, I will say, money well spent. It's I can't stress this enough. I've heard so many horror stories of people that didn't properly protect themselves and they lost everything. And there's just, once that happens, there's really nothing you can do. So, but no, Peter, thank you again. And thanks.
Pleasure. Good to talk to you, Colin, and best of luck. Stay in touch.
Thanks, everybody.
Take care.
Bye.
Thank you for listening to the HoCo Cyber Collective Podcast. Stay connected, stay curious, and join us again for our next episode.